Well, Mr. Brockbank, the best laid plans of mice and men. It's 2 o'clock still. Never mind. Perhaps it would have been later if I hadn't said 5-2.
Yes, indeed. Very good. Well, I'm going to start with the Mura itself, which is in the core bundle at tab 12. And I'm going to be quick because you've obviously looked at this in some detail. As I know you would recognise, we have at the top left-hand corner, first page, page 181, an agreement number. And then in the middle of the page, we have the word agreement with faculty of reinsurance, the agreement. And what one then has is declarations over a couple of pages, and then terms and conditions. Exactly as one would expect to see in any conventional contract of insurance or reinsurance. I've already made submissions about whether it's a certificate or not, and I've given you, I think, interrupting my learned friend this morning, I gave you references to Mr. Gilman's evidence. His evidence is that these sorts of documents are commonly referred to in the US market as facultative certificates, but they are binding contracts of reinsurance, and there is, if you like, no magic in the word certificate. And the additional point I would make is that that certificate in that context is not being used in the way that it is sometimes used in the insurance and reinsurance context, simply to refer to a confirmation of cover. And I've made submissions about that before the break. And I was going to show you, actually, just to make good one point I made before the break, if we could just turn back to the MRC in the previous tab, and in particular to page 148, where we have towards the bottom, about just over an inch up from the bottom of the text on the right hand, on page 148, the words that my learned friend showed you about certificates. I just wanted to draw attention to the fact that it says agree if required to allow agent to issue certificates, and at the end of that particular clause, without advice. And that, in my submission, makes good point I made before lunch, that that's talking about a certificate that might be issued by a broker or such, without the reinsurer having to look at it, certainly without the reinsurer having to consent to it, or consider and agree it, as the email we looked at before said about the Mura. So it is talking about a very different creature in my submission. Then if we go back to the Mura, that's page 181 at 12, a point was being made by my learned friend about the way coverage is described in the middle of this passage. To avoid dotting about, I'll just give you the reference, but that's almost identical to the way that coverage is described in the MRC, which you have at page 147 of tab 11. So in my submission, there's really nothing in the point that somehow this agreement is not covering all of the risks under the underlying policy. And for good measure, Mr. Gilman's evidence again, paragraph 11, is to the effect that the very purpose of these documents is to confirm that the reinsurance is back to back with the underlying cover. And so his evidence is really the contrary of the submission that my learned friend was making, that somehow this might create a gap. And I say that there's really nothing in that point. If we then go over the page 182, we have at the top of the page, and my learned friend essentially excised this part of the document when he was making submissions. We have terms and conditions, and we'll see that the left-hand two columns are referred to as required terms and conditions, and the right-hand additional terms and conditions if applicable. So those are, this has all the hallmarks of being in agreement with important required terms and conditions. Two other observations on this page. You'll see the premium payable due date is the 1st of September 2021. That is different from the premium payable date in the MRC, which was the 28th of September. So somebody has gone to the trouble of inserting this date in a document that my learned friend is inviting you to regard as purely administrative, and made that change. The other aspect I wanted to draw attention to on this page is the service of suit details, where you'll see that for those who practice in insurance law, the familiar firm of Menders and Mount are identified as being able to accept service of suit in the United States. The significance of that is that if you keep that open, but look at the same time as the prior year, Mura, which is in the supplemental bundle, tab 2. At page 40, you'll see that service of suit in that year was regarded as not applicable. And so I stood up, I think, before my learned friend finished, and at one point said that there were differences. This is an example of a difference between the Mura in the prior year and the Mura in this year. And I say that's of some significance. Somebody has specifically introduced into the 2021 Mura in the core bundle service of suit provision. And I say that is very much consistent with the idea that this document has relevance to, and is intended to be contractually binding in respect of issues of jurisdiction as they apply to this contract. And then I won't take you through the terms and conditions that then follow, just to highlight on pages 183 and following. If I can just highlight a few points. You have in 3.
Sorry, 3, so we're on page.
I beg your pardon, my lady.
No, my fault.
83 of the core bundle.
Oh, sorry.
Sorry, you put away the supplemental bundle. I should have said that. Sorry.
No, it was my fault because I was looking at something else when you spoke. So
Yes.
we're now at clause 3.
Exactly. I'm going to pick out 1 or 2 aspects of the terms and conditions. Clause 3 is effectively a back-to-back cover provision. The reinsurance agreement is going to be subject in all respects to the same risks, terms, etc., as the captive policy, effectively. And that is significant for 2 reasons. One is that it incorporates terms from the captive policy, which is an answer to my learned friend's swept away argument, which I'm going to come to. But also, it again contradicts the submission that was made that somehow this was narrower cover than the MRC. It plainly is not. The books and records provision is 4. That is a significant right for the reinsurer, which is in this document, but not in the MRC. And one of the points I make in answer to my own friend's swept away argument is that one can make the point the other way around as well. That if he is going to contend that this is a document of no contractual effect, then one does lose from this document clauses such as clause 4 that the parties have gone to the trouble of agreeing and that are new, additional to the MRC. The only other clause that I was going to refer to, obviously you are aware of the arbitration clause in 13, the governing law clause in 17, and then one has the entire agreement clause at the end, near the end at 26, which starts at the very bottom of 187 and goes on to 188. And the only point I wanted to make about that is to submit that we don't accept that our argument and reliance on that clause is circular. It's the existence of a clause in these terms is obviously more consistent with this Mura having contractual effect than not. We say it would be commercially illogical to suggest that a document that contains an entire agreement clause in these terms was intended to be merely administrative or of no effect. why, I ask rhetorically, use a form of wording that contains such a clause if this was merely intended to be a confirmation or some sort of administrative tidying up. So I do say that the presence of this clause reinforces the other arguments that we make, that the terms and structure of this document strongly support a conclusion that it was intended to have contractual effect.
In the last part, I had thought this was irrelevant, actually, because the first question was, is this an agreement intended to have contractual relations? The last part does seem to say that this agreement, if it is an agreement, shall supersede all contemporaneous or prior agreements, written and oral, between the parties with respect to the subject matter.
That's right.
And that would seem to indicate the earlier contract, even under English law.
Yes. It's worth saying, and I'm sure your Lordship has this in mind, that obviously the meaning and effect of the clause is strictly a matter of New York.
Yes.
But yes, I absolutely agree with what your Lordship has put. And that's really the submission that I make. It reinforces the idea that this is now the parties' agreement.
You have not your primary argument about variation, that is the existing English agreement, English law agreement, with two significant clauses changed. This does look like what's been called implied precision, or arguably.
Yes, and the implied precision variation argument has, or rather the importance of the distinction has gained relevance in the context of this appeal from where it was at first instance. In my submission, it is principally relevant in terms of whether it matters. It's principally relevant to the contract change argument that my learned friend has made, and I want to come back to it in that context. But
it's an argument that grows on you the higher up the appellate chain you go, as Mr. Anthony Lloyd once said.
That's absolutely right.
It has other consequences, because it would mean, for example, it's unlikely, as a matter of English law, that clauses in the English agreement would feed into what I would call the American agreement, although that would be a question for the American arbitration tribunal. But it looked at one stage if you wanted to have the English clause plus the ones you liked in the American one, but it may be that that's not.
Yes. Well, can I put it this way? At first instance, the focus was very much on the jurisdiction provision, rather than as it were, everything else. But yes, I'm certainly not making a positive case that anything from the MRC remains. I don't need to for my purposes. And I'm entirely content with an analysis which is that this agreement supersedes the previous one.
I mean, there is an oddity about the entire agreement clause and some of the other clauses, because I think it is said that the New York arbitrators could, as it were, pick and choose some clauses from the MRC, notwithstanding the entire agreement clause, because New York law may allow them to do that, which
Yes.
all sounds a bit odd.
There is an issue of New York law on the evidence as to it. So my client's evidence has been to suggest that yes, at least in some cases, entire agreement clauses may not obviate everything that's come before. If my recollection of the evidence is correct, the evidence on the other side was, well, that's not right. It would eliminate what's gone before. It is a question of New York law. It's a question that your lordships can't resolve on this application. But in my submission, it doesn't matter for present purposes, in the sense that what one's concerned with in this part of the case is, well, what is the objective inference as to the party's intention? And as to that, I would say that the natural reading of the clause as a matter of English law anyway supports the submission that I made, which is that the objective intention was to supersede what had come before.
Just so I'm clear, I think it is clear. We have to decide whether it's a matter of English law, the law of England and Wales, more accurately, the entry into what I call the American contract, and you know what I mean by that, brought about a situation of implied rescission.
Yes.
And if that's the question that we're deciding, what any of these clauses mean, whether any of these clauses in the American agreement have carried with them other clauses from foreign agreements, in this case included, will be entirely a matter of New York law for the arbitration tribunal. But we have to decide as a matter of English law, applying Morrison, Barron, and all those other ones.
Yes, precisely right. You put it absolutely right. Can I then move on from this? You'll appreciate that our basic submission in relation to the Muir and the circumstances surrounding it is that it was a straightforward situation of offer and acceptance. They put forward this document saying, please consider it and agree it. And my clients then did so. And the parties subsequently performed the contract, including by payment and receipt of premium. And the only other thing I need to say about the Muir before I move to talk about the MRC for a little bit is to attempt to rebut my learned friend's submission. This is a sort of non-negotiated standard form and therefore hierarchically less significant. Plainly that doesn't arrive in respect to the first 2 pages, and my learned friend then was driven to draw a distinction between different parts of this document. The other submission I would make is that the parties were very familiar with this form. Both Mr. Gilman's evidence and Mr. Hennessy's evidence for my clients support that proposition. So it's unsurprising that they were happy with it in its familiar form. Certainly the fact that they didn't, as it were, put a line through things does not lead to an inference that somehow it's of less contractual weight than some other document. And as I'm going to come to now, the contrast is in any event a false one, because the MRC is nowhere near as bespoke as my learned friend has been submitted to. So, to deal with that point, the MRC's supposedly bespoke nature, what one finds in the MRC, and you've obviously got it at tab of the core bundle, I'll try to avoid going to too many references for reasons of time, but one has a large amount of essentially standard form material from the default MRC. That includes default provisions such as the subscription agreement, which starts at page 169, the security details section at 177. These are all parts that describe the MRC implementation guide as admin. And there's no evidence that any of that was bespoke in any sense. Secondly, a substantial part of what is in the MRC is essentially material copied across from the captive policy. That includes, obviously, details of the insured, the period, interest, etc. One has, at pages 151 and following, pages of the original policy deductibles, which are taken from the captive policy, and original sublimits at page 154. And this point is in part been made by my learned friend already, but the conditions that he was drawing to your attention at pages 148 and 149 very largely reflect and copy across the terms of the captive insurance. And you'll see, just to illustrate that, how many times the words as per original policy wording appear in this part of the document.
But that's not a reference to the captive insurance.
Not directly, my lord. It's a reference to the underlying layer of reinsurance,
Yes.
which then has the same sort of language. But in that context, the original policy wording is the captive policy. So there's, if you like, a two-layer incorporation. But the effect of it is ultimately that it is, in a way, a reference to the captive policy. Right. And the significance of that, I'm going to come to this, the significance of that is that when my learned friend said, oh, well, you know, all these clauses will be swept away if you move to the Muir, in large part that's not right, because the Muir incorporates the captive policy and therefore preserves all of the clauses which are described as per original policy wording. So the thrust of the submission, and I should also mention, I'm going to come back to this, but I should also mention the excess physical damage form, which my learned friend showed you at pages 157 and following. that also is a standard form boilerplate set of wording. And
What about the communicable disease clause, which for a contract in July 2021 might have been quite high in people's minds?
yes, but I'm going to come to that. You're absolutely right, Mel. That is the one clause that I can't say survives if the Mura replaces the MRC. There is a communicable diseases clause in the captive policy. I'll show you that in due course. So it's not that it falls away entirely, but it's fair to say that there are differences of language between the two clauses. And so I do need to address you on that point. If I can come to that in a moment, I'm going to deal with the fate of these various clauses in a moment. But the point I want for this instance is that when one takes away the content I've just been describing, there's actually very little in the MRC that is bespoke in any real sense. And still less was individually negotiated. In my submission, what has happened here is that Lockton, the broker, is using an MRC for its European placements on different layers of this programme. And indeed, Mr. Gilman himself refers to it as a standard form MRC. That's paragraph 38 of his statement. It was a convenient vehicle to get the reinsurers to sign up with a document in familiar format. But in my submission, the use of the MRC has no more significance than that. It isn't a document that, because of what it is, deserves any special significance or should disturb what would otherwise be the conclusion drawn from the sequence of events that we have in this case. There's one particular feature of this that's worth emphasising. There was no negotiation of or reference to the jurisdiction clause in the MRC between these parties. To use Mr. Killen's words, it wasn't discussed. It is not in the MRC because the parties discussed and agreed it. And it would be wrong to approach this case with any presumption that the parties were particularly in favour of English jurisdiction. It is there because that is the clause that Lockton had generally used in the MRCs it was using for placements of this programme.
Well, it's there because an MRC would have that kind of clause in it because it's the standard form used in the London market.
Yes, exactly. And you have to fill something in.
And it was a term of an agreement, and you accepted it as an agreement, and the starting point is that if nothing else had happened, this would have governed the law and the place. So
Yes.
the side who wants to minimise the other side's documents, but the fact of the matter is each of them, in your case, are equally valid.
Yes, absolutely. I think all I'm trying to do, my lord, is to counter the suggestion that's being made that somehow the MRC is a superior document.
Yeah.
If I leave you with the impression that they are, as it were, equal, then I've done my job on this part of my submission.
You're not in any way trying to say the MRC was lesser, even during its short, in your case, brief life on this earth.
No, I'm not. I don't need to submit that. I'm simply trying to submit that it doesn't have any special status, and certainly it would be wrong to regard it as deserving special status by reason of it having been specifically negotiated or bespoke in the way that was perhaps being suggested. And I also don't accept, if it matters, that the jurisdiction clause in the MRC is any more specific than the arbitration clause in the Euro.
It is a relevant part of the process of assessing the intention of the parties 7 days later to take into account that they had agreed a legally binding contract which put jurisdiction in this country and made this country the law of the contract.
Yes. And
the question is, were they intending to do something radically different 7 days later? That's the real question, isn't it?
Yes, absolutely. That is the question. As your Lordship puts it, we accept that if this document stood alone, that would be a binding contract, but it doesn't. And that's the critical part of the facts in this case. I'm not going to deal with generali and pelagic, which my own friend relies on for saying that bespoke clauses should take precedence over standard form clauses. That's a case about situation where your bespoke document incorporates by reference some other document. It's not a case about having two documents in the way that we have here. It really doesn't cast any light on the question of which of these two documents prevails. That then does bring me to what I call the swept away argument, which is the argument that it would be implausible if the parties abandoned what are called bespoke terms that have been agreed in the MRC within 8 days. Of course, one of the false premises that I say that argument is based on is the idea that the Mura emerged out of the blue after 8 days. It didn't. The parties were always contemplating that they would agree the Mura. So that immediately, in my submission, draws a lot of the force out of any submission that, well, why have they suddenly changed their mind? If one looks at the pre-contract correspondence, they haven't changed their mind. They've done what they were always intending to do. But I want to try to take this in a slightly forensic way, if I can, by looking at the email that you were showing this morning, which is Mr. Hennessy's email of the 16th of June 2021, which is in the supplemental bundle at tab 8. On the second page of that email, at page 162 of the bundle, is the list of clauses that Mr. Hennessy identified as to be included unless otherwise contained in final SPIP or policy form. And just to tell you where I'm going with this, these clauses fall into 3 different categories. One is clauses that although he's identified them here, they didn't in fact make their way into either the MRC or the Mura. The second is clauses that are in both the MRC and the Mura. And then the third, which is a category of 1, namely the communicable diseases exclusion, is a clause that was in the MRC and then is not in the Mura.
When you say some in both, you mean some in the Mura by virtue of being incorporated from the either the first layer of the reinsurance or the captive policy.
That's how it works. So just to illustrate those categories, we can take just by way of example the biological and chemical materials exclusion, which is I think the fourth one in the list. Mr. Hennessy has referred to NMA 2962, which is the standard form wording. The clause in the underlying policy is in the core bundle, tab 9, page 130. And that is not NMA 2962. And just to make good that wasn't in the MRC either, the clause that Mr. Hennessy had requested was not in the MRC either. If one goes through page 148 and tab 11, at the bottom one has chemical, biological, nuclear, radioactive, pollution or contamination exclusion as per original wording. So that's an example of something Mr. Hennessy had requested, but which he doesn't get. There are 3 other examples in this list. I won't go through the same process. for those, but I'll just name them. The war and terrorism exclusion, the mould, mildew and fungus microorganism clause, and the radioactive contamination exclusion. The significance of that part of the analysis, of course, is that it again gets to the question of whether this MRC was a bespoke negotiated contract. Mr. Hennessy had made stipulations, they were not incorporated. The second category are clauses which are in the MRC, but also preserved in the MURA by virtue of the incorporation of the underlying reinsurance and then the captive. And an example of that is the asbestos exclusion, and probably if you still have the MRC at page 148, you'll see that the asbestos endorsement is said to be as per original policy wording, which takes us to the captive policy at page 129, tab 9, page 129, for example. So one finds the asbestos endorsement. Now, although it doesn't say so, this is the LMA 5019 wording that Mr. Hennessy had said he wanted. So this is an example of a clause which is not swept away because it's still there in the MURA. And others in that category are the cyber exclusion and the sanctions limitation and exclusion clause. So, in respect of all of those, there is nothing in the swept away argument. They either weren't there in the first place, or they're still there after you've agreed the MURA. That does then bring me to the communicable disease exclusion. There is such an exclusion in the underlying policy, and you have it in the endorsement that you looked at this morning at tab 10 of the core bundle. And it's at pages 144 to 145. Now, I stood up when my friend showed you this endorsement and said we thought it was an endorsement to the underlying policy. We still think that. Can I just identify why, one of the reasons why we say that? If you go to the previous page, 143, you'll see, for example, cancellation about an inch down from the top of the page. And there's an amendment so that it reads, this policy may be cancelled at any time at the request of the insured, or it may be cancelled by the company by mailing to the insured act. So it's quite plain that that is a clause dealing with the relationship between the insured and its insurer. And we understand that all of these clauses are incorporated into the captive policy. And in case there's any doubt about that, I'll just show you one clause in the captive policy, which is in the previous tab, page 141, the very last page in that tab. There's a clause called a non-concurrent facultative reinsurance terms and conditions endorsement. And I'll let you read that. Essentially, that's saying you don't get any more cover under the captive policy than you are getting under your reinsurance. So if, contrary to the submission I've just made, the endorsement in the following tab is an endorsement to the reinsurance, it nonetheless feeds through to the captive policy by virtue of this clause. Now, can I come back in a moment to why I say that the communicable disease exclusion doesn't support my learned friend's conclusion? I just briefly want to deal with some other clauses that he has relied on in the context of this line of argument. It's already been shown that the excess physical damage form, which is at pages 157 and following of tab 11 in the MRC. And my learned friend has made assertions as to the significance and importance of this language in the context of the reinsurance. But what's striking about it is that all of this is language talking about layers of excess insurance. And indeed, this is boilerplate language that one sees very frequently in towers of excess insurance, governing the way in which insurance policies interact in that tower. It's not clear to us on this slide that it is actually germane at all in the context of the reinsurance, let alone that it was regarded by the parties as of significance. It goes without saying, perhaps, that there was no discussion, negotiation, or agreement of this wording specifically. So it's not actually, in my submission, terribly surprising that parties didn't feel it necessary to copy them across into the Mura. There are, if it matters, and I don't want to get into the detail of this because it's ultimately would be a matter for the New York Tribunal, but there are provisions in the captive policy which address similar concepts to the types of issue that are being addressed here. So there's, for example, a priority of payments clause in the underlying, the captive policy, and a step-down, drop-down clause. So it's not right that these concepts just go untended to in the event that the Mura supersedes. The other clause that my learned friend mentioned that I should briefly address is the claims control clause, which is at page 167. Again, this clause wasn't discussed, isn't spoken in any real sense, but it's dealing with notification and provision of information and claims cooperation. The Mura has its own equivalent provisions. So in tab 12, you have, for example, at 5, clause 5 on page 184, clause dealing with notice of loss. The same clause deals with the provision of information. And the last paragraph of clause 6, which is in the top half of the right-hand column, deals with claims cooperation. Now it's right to say that there are differences in detail between those provisions in the MRC and the Mura. But they are both workable, recognised forms of wording to deal with these issues. So again, it would be wrong to proceed on the basis that somehow the Mura is deficient because it leaves out of account these types of things. So that's where we get to on the swept away argument. And I do say this, that we really are left with just communicable diseases endorsement on a proper analysis of how this happened, worked. And we say that that is explicable on at least two bases. It may well be that the parties were content with the alternative provision in the captive policy. Indeed, without a detailed comparison of the two, one loses something of the force of my own friend's argument that it's extraordinary that you would swap one for the other. There are differences, but in my submission, and I haven't got time, I'm afraid, to address them, but they are subtle differences rather than fundamental differences. it's equally possible that parties, as parties do from time to time, overlooked this aspect. These things happen when parties are entering into contractual documents. Sometimes some things slip between the cracks. It is not implausible. In my position, it would be wrong to reverse engineer a conclusion as to the effect of the Muir by focusing on this one clause and assuming that the parties had that in mind and therefore cannot have intended a document which otherwise looks like a binding agreement to be a binding agreement. That, in my submission, puts far too much weight on that isolated clause.
Whether they were in fact content with, or overlooked it, or whatever else the explanation may be, is not really the question, is it? I mean, if we're looking at their subjective intentions, it may very well be the case that they were at cross purposes, and on one side they thought that the MRC was going to be the operative contract, and on the other side they thought that the MURA was going to be the operative contract. What we're concerned is with is a slightly artificial, but nevertheless necessarily so, exercise of looking at the position objectively to put some sort of meaning on what they did.
Yes, and I think both my learned friend and I are making submissions in a sense to inform that inquiry. We're not asking you to find, certainly on my part, and I'm sure my learned friend as well, I'm not asking you to find they actually did subjectively think X or Y. But my submission is this, that my learned friend is essentially inviting you to conclude that the only inference one can draw from the absence of the communicable disease exclusion in the Muir is that they cannot have intended this to be contractually binding. I am saying that is not the only inference one can draw. There are other available explanations, and therefore it is not actually a powerful factor when you're making the assessment that your lordship has just described, the objective assessment of what is going on here. This is not a factor that should sway you one way or the other. And I've made that point, I'll move on from that. So I do say that in broad terms, this swept away argument is founded on false premises as to the nature of the MRC and how it came to be the terms that it was. And then as to the effect of the Muir, once one takes into account the incorporation of the captive policy terms. Then I was going to deal very briefly with commerciality, because in large part my friend's submissions of commerciality are bound up with this swept away argument I've just been addressing. But I do say this, that it is not extraordinary at all what has happened here. It's perfectly understandable that the MRC is being used as a general document for the placement of various elements of the reinsurance cover. And you've heard today about the Beasley cover. And in the supplemental skeleton argument, my learned friend has also referred to the decision of Mr. Stephen Housemann KC in another element of this program where the MRC also featured. So the MRC appears to have been, as it were, a general vehicle being used to place a number of elements of this program. But it's not at all inconsistent with that for specific reinsurers, including my client, to then agree the Muir to encapsulate the terms on which they wished to write the reinsurance. We say that the reason there are two documents is because they're essentially performing different functions. And that's why they both are agreed. And for what it's worth, which is probably not much, if anything, that is consistent with Mr. Hennessy's evidence.
And just to spell it out, the two functions are?
The two functions, the MRC is a vehicle to bind various bits of the market. So you're going to the market with a useful vehicle. It's in a form that's familiar to everybody you're dealing with, and saying, sign up to this cover. The Mura is then the reinsurer-specific document, in our case, by which partner is saying, these are the terms, including as to jurisdiction and applicable law, on the basis of which we want to provide cover.
But the problem is the same function, legal obligations and rights are being granted and accepted under one document. Admittedly, on your case, it only lasted for 7 days. But there's no reason to read that as temporary. I know you say it was the holding operation, but it was a contract. It allocated rights and liabilities in this field.
Yes.
You say, what's the next document? It does the same.
Yes.
And the question is, why on earth would they have done the same thing twice within a week?
Yes, but I do say that it is significant that they contemplated from before the MRC was signed that the Mura would follow. So it isn't quite as extraordinary as I think it's presented by my own friend. As I said, it's not extraordinary at all, because the vehicle that was available to bind the reinsurance at the date that it needed to be bound was the MRC. And I accept that if that had stood alone, it would then be, for the remainder of the policy period, the binding contractual document. But they knew they were going to agree to the Mura. They knew what the terms of the Mura were, they were familiar with it. They then do agree with it. And in my submission, that's what they intended to do. They intended it to be a contractually binding document.
But how does that work when they entered into a Mura and you showed us it, but actually it has a number of different provisions, which you highlighted, the previous year? What was going on then? I know that's a tangential question, but you've got a document which is very similar,
Yes.
which is signed up to the year before. First you get your MRC, then you get your Mura, as you would call it, but in a different form, slightly different form.
Yes.
Then it's said that one is subject to the other the year before.
Yes.
So what kind of vehicle was the Mura on that occasion?
Well, on our case, it's the same kind of vehicle, and that we don't accept that it was subject to the MRC, and that we've got submissions in our skeleton. I'll come to this if I can, if time allows. But so we don't accept the premise of the argument, because the endorsement does not contain, in our submission, a clear reference to the MRC, and therefore we don't accept that that's what was going on there.
I suppose you're wrong about that. What's the answer to my lady's question then?
Well, what the parties have done in that year is to enter into an endorsement which puts the Mura into a different position from the position that it would otherwise have had. That does not happen in the year with which we're concerned, and therefore, in my submission, one can't say that they intended the same thing in the year with which we're concerned. Indeed, the inference is that they didn't. They didn't follow the same process.
But supposing that the effect of the 2020 endorsement is that the Mura is subject to the MRC,
Yes.
what then is the Mura in that year for?
Well, can I put it this way? One thing that is striking about the endorsement in the prior is that it does refer to, perhaps it's easier if we just look at it rather than making submissions. It's in the supplemental bundle at tab 3. And it says that the contract is amended. And the second paragraph says it is hereby noted and agreed by the underwriters with effect from inception the following added to the conditions of this contract. And so, in fact, at least to that extent, this is inconsistent with the idea that the Mura is simply an administrative
So can I just understand this? The first sentence is here, the conditions of this contract. Is this contract the 2020 MRC?
Well, it's the contract with the unique market reference at the top, which is the reference which appears both on the MRC and on the Muir.
So that could be either then, but it can't be the Muir, can it? Because the Muir is referred to the next line down. The agreement of is agreed subject to the terms and conditions of contract 3490. So this contract, if it's a reference to the one at the top, it must mean that this contract is the MRC, mustn't it?
Well, it's certainly the reinsurance, which until this moment is embodied in the MRC.
Yeah. And then the agreement of facultative reinsurance is agreed subject to the terms of the MRC. All other terms and conditions remain unchanged. That sounds as if all other terms and conditions of the MRC remain unchanged. That does sound as if it keeps on life support the MRC.
Well, yes, if one accepts that the reference to contract PRP NA 2000-2003-490 is the MRC, but the
why would you use a stamp with a seal and the JW, whatever it is, unless you were thinking in terms of the MRC? This is all the hallmarks of the MRC, doesn't it?
Well, can I deal with that in stages? Mr. Gilman's evidence, paragraph 25 of his statement, which is in tab 13, page 178, is that the number that is written down here matched the policy number of the 2020 captive policy. So it's not clear in my submission that there is a reference to the MRC.
Sorry, just very quickly, I did deal with that point. There was the numbers were transposed, the 409, 490.
I don't think we have the underlying policy from the prior year in the bundle, so I can't confirm or deal with that. But that's what Mr. Gilman's evidence was anyway.
The Mura, if it's the agreement factor of reinsurance, isn't in this document on page 50. It can't be the document that is the RPNA number, because the agreement in the second paragraph is made subject to that other document.
Yes, but sorry, I wasn't being clear. That other document may be the captive policy.
Well, the captive policy rather than the MRC.
Yes.
And this is the point about, is it 3490 or 3904 or something?
Yes, and I don't think we have the documents from the prior year in order to resolve that particular question. But in terms of what happened in this prior year, it's undoubtedly an endorsement that's sent in these terms, and my clients stamped it. For what it's worth, Mr. Hennessy, who was in charge of this cover, was aware at the time that this all happened. And in my submission, one needs to be a little bit too careful about reading too much into what parties were intending to do. But the submission I was going to make is that if one then is left in the scenario in this prior year, where both contracts are applicable, because the Bureau has been added to the conditions of the contract, as noted here. One is then left in a situation of having to construe the word subject to. And one is then into the part of the case which my friend didn't have time to deal with, about whether one actually can then read the two clauses together.
But you couldn't read the jurisdiction or the enforcement clauses together, but since this facultative thing is subject to the other one would assume that means that the jurisdiction and the enforcement clauses are subject to what's in the MRC, if it's the MRC.
Well, no, because the way the law works is that if one has, as it were, two clauses in the same contract, before one gets to the hierarchy language, I put it that way, this language here is subject to hierarchy. Before one gets to that language, one sees whether one can read them side by side. And if one can, then one doesn't need them to subject one to the other.
Yeah, but if we're dealing with equivalent clauses to the ones in the current year about New York law, New York arbitration, English and Welsh law, Court of England and Wales, you can't read those together because they, well, I know you say you can, but it seems for the moment you can't read those together. Then the one is subject to the other. One has to take priority. One is dominant and the other is not dominant. And that's what subject to really means here, isn't it?
Well, obviously, if I assume against myself the arguments that I would otherwise make as to the way in which they work together, then I think one must ultimately end up at that position. Yes.
But there's not one contract replacing another one. There is the thing that might be the MRC, and we think is the MRC, although you doubt it, and that thing has been changed by the agreement, the mirror, subject to any changes in the mirror or anything in the mirror not conflicting with the MRC. That's what this means, isn't it?
Well, I may not have time to develop submissions, but you have the submissions, at least in writing, that we say that two clauses can be read together.
Oh, I've got that, yes, and I'm assuming that's wrong for the moment. Persuade us that they're not, but we're assuming that you can't really read New York as meaning London.
Yes. And then I suppose the question for the court is, well, what is to be inferred from the fact that the parties did not do this in the following, and one doesn't have this language in the following, and one does not have any provision that the mirror is subject to the MRC.
I mean, it looks as if somebody simply slipped up in a way, doesn't it? Because there is in the previous year what looks like an attempt, whether it's successful or not, to make clear that the MRC prevails over the mirror. And in Mr. Hancock's case, which you mentioned, there's a hierarchy clause in that case in the mirror, not in the MRC, making clear that it was held to make clear that the MRC prevailed, but whether deliberately or by oversight, it's not there in the particular contract or contracts we have to deal with.
Yes, and in my submission, it isn't the right inference to draw that, as it were, they intended to do something other than they did do. If the facts we have are the ones that we have, one can't then infer that they actually meant to do something other than what they have in fact done.
Yes, well, it's not binding on us, of course, but I suppose you rely on Mr. Hancock's reasoning that without that hierarchy clause, then the party equivalent to you would have won.
Exactly. So we are in precisely, we're in, if you like, we are in the Hancock position minus the hierarchy clause. And so I do say that he was right in the same way as the judge was right about what happens in that scenario. Can I then deal with the contract change argument, the GUA argument? You will understand what I mean by that. We make essentially 3 points in response to this. First, we submit that the MRC does not stipulate that the GUA must be complied with for contract changes to be valid. Second, we say in any event the GUA is inapplicable to a situation where you have a bilateral contract between one reinsurer and one reinsurer. And third, we say that if necessary the GUA was complied with, or any departure from it was de minimis. As for the first point, we need to look at the MRC, which is at the core bundle tab 11.
You really need this argument, just so I'm clear, for your primary argument, the variation. It doesn't matter if it's rescission. You need, my point was rescission. I've got that right, have I?
You have. I should have said that really that's our fourth point. It doesn't matter where in the hierarchy it comes. But we certainly make that point. My learned friend didn't accept it, but I'm going to come on to say that that's absolutely the right analysis. So I only need this if it isn't implied rescission, or alternatively, if implied rescission is nonetheless somehow caught by the GUA. But can I nonetheless deal with it? So we need to look at page 150, tab 11. And the relevant words are the second paragraph of the against insurer contract documentation. And what it says is any further documentation changing this contract, agreed in accordance with the contract change provisions set out in this contract, shall form the evidence of such change. Now, my solution that is not the same as saying that change can only be effected in that way. It's dealing instead, as one would expect by something that appears against the heading insurer contract documentation. It's dealing with evidence of any change. And the reason that it's expressed in that way is because the GUA is, as I'm going to come to, all about ensuring that changes bind following underwritings. Hence the significance of evidence of those changes. So that you can go to the following marking and say, look, this is a change that binds.
But don't you have to read that in conjunction with page 169, which does seem to be slightly more exclusive language?
Well, in my submission, one reads it the other way around. When it gets to 169 in the context of evidencing a change. So I accept that that's the boilerplate language of 169, and this is, as it were, language that appears in every document that looks like this. It says all changes to be managed and agreed. But in my submission, that part of the contract is not imposing a specific obligation. It is just describing the way in which the GUA operates. And then the obligation, if you like, such as it is at 150.
If you look at 150, even that says, any further documentation change this product shall form the evidence of such change. But it has to be documentation which evidences changes agreed in accordance with the contract change provisions.
In order to evidence the change, yes, because
No, agreed in contract. There are two things going on. There's there is a change, and there is how do you prove it. And the latter bit says shall form the evidence of such change. But change, what change? A change as described previously, agreed in accordance with the contract change provisions set out in this contract. That's what is a change, and that's what's going to be evident.
yes, but in my
If it's not a change in accordance with the contract change provisions, then it can't be evidence, and the implication is it isn't a change.
well, it's that last part that I would take issue with.
Right.
I would say that this is dealing with a scenario. I want to show you the GUA to try and support this submission. This is dealing with a scenario in which you need to be able to go to other underwriters and say, here is a change that is now binding. And indeed, if one looks at the subscription agreement part of this contract at pages 169 and following, there are certainly whole parts of this material which can't sensibly have any application here. So, for example, on page 170, the whole claims agreement parties section is inapplicable to this scenario. And for example, if one goes over to 171, there's a section dealing with the position for Lloyd's syndicates and so forth. And indeed, the claims administration language on 171 similarly doesn't apply to this contract. This is simply boilerplate language appearing in all NRCs, but not actually apt to a bilateral contract such as this one. The next point under this heading is to look at the GUA itself, if I may. That's in also in the core bundle at tab 13. And I wanted to start, if I could, at page 194 at 13. And it's worth looking at the purpose of the GUA at 2.3. The General Underwriters Agreement provides a standardised arrangement in respect to contract change agreements. The purpose of the GUA is to, first of all, create an agreement between the subscribing underwriters on a particular contract for management of changes. Second, to clarify the extent of the delegated authority to the slip leader and agreement parties. And the last bullet on this page, allow a single slip leader and the agreement parties to agree contract alterations where empowered to do so by the GUA. And over the page, at the top of the next page, ensure all underwriters are notified of alterations where appropriate. So there's no doubt that the purpose of the GUA is tied up with the relationship between insurers. It is in essence an agency or an authority agreement concerned with making provision for one underwriter to act on behalf of others on the same policy.
I mean, in a nutshell, is it your submission that if you want to buy in the following market, you have to follow the GUA procedures, but if there is no following market, then the GUA simply doesn't apply?
Precisely.
Is that where you're going?
That is precisely where I'm going. And I'll take this quickly because I appreciate you have the point. But if I could just draw your attention to the first paragraph of under 2.4, which makes the same point as I was just identified. GUA is an agreement between subscribing underwriters on a particular contract relating to the level of delegated authority in respect to placement alterations. And then finally on this element, a couple of pages further on, at 197, the text underneath the italicised text, in the top half of the page, the GUA determines the basis upon which the specified slip leader and agreement parties for insurance and reinsurance risks to which this GUA is applied may act as agents of the other underwriters subscribing to those risks, etc.
But it's really three, isn't it? On page 198, that sets out what alterations are covered by this. And they're all alterations, are they? Schedule 1, Schedule 2, which involves more than one other underwriter. It's not a bilateral contract.
Yes, that absolutely.
But it's really all the rest is interesting. It's really three that tells us what it applies to.
Yes, I mean, I rely certainly on the statement of what the purpose of the GUA is, but it's absolutely, as you say, it's consistent with the particular types of alteration that are then identified in 3 on page 198. And so we say this is really not generic to a scenario that we're in, and it ties into what I say is the proper construction of the contract change provision we were looking at in the MRC. And explain why it's talking about evidencing changes. The next point under the GUA heading is that we say, if necessary, that the Euro complies with the GUA. Can I just try and identify why we say that? The appellant has identified 3 reasons why, in its case, the GUA was not compliant. And for your reference, that's paragraph 50 of the appellant's skeleton. 1 is that there was no contract change endorsement. 2 is that the GUA stamp was not incorporated. And the 3rd is that the date wasn't entered into the GUA stamp. So, as to the first point, if you still have page 198 of the core bundle open, 2.6 defines endorsement. And it's in very broad terms. Any document evidencing an alteration to a contract of insurance or reinsurance, whether in the MRC format or in another format. So, it's not prescriptive in any way. Hopefully the least controversial submission I'll make today is that the MURA is a document. Now, I understand to be argued on the other side that in order to evidence an alteration, the document needs to refer to which clauses in the original document are being changed. That's paragraph 53 of my little skeleton. We say simply that reads far too much into the words evidencing an alteration in 2.6. All that evidencing an alteration there is that you have something which records the change that's being made.
Sorry, if I can just take you back to page 169 of the core bundle,
yes,
which is the place where contract changes are dealt with, and seems to be all about communicating with the following market.
Yes.
I don't know what ACORD messages are, but it looks as if it's some kind of electronic messaging service whereby the following market would get notification of changes which have been agreed on their behalf by the leader. Is that what it is, or is it something else?
That's also my understanding, my lord. I don't think there's any evidence of that effect, but that's how I understand it, that there is some sort of digital system which enables communication with participants.
So when that page says all changes to be managed and agreed in accordance with the general underwriter's agreement, and then sets out that procedure, and when the previous page, which talks about evidence in accordance with the contract change provisions, that is, on one view, your view, I suppose, all about how you should communicate with the following market.
So
It's got,
exactly.
and hence in paragraph 2 at page 169,
Yes.
it says the parties may negotiate and agree any contract change in any legally effective manner, but you've then got to tell the following market by using the ACORD system, whatever that is.
Exactly. And another point that arises from this part of the is that there's nothing sacrosanct about the stamp, GUA stamp, and all that. Certainly, as far as one's using ACORD, you can agree a change in any legally effective manner. Yes. So there is a tension here between what happens as a matter of convenience and practice, which is that frequently people do use the GUA stamp, and that's how one communicates it, and whether that is actually an obligation to be imposed in this contract and is relevant. And I say it isn't. Can I just complete the point about this being an endorsement? So the first objection that my learned friend takes to the Muir is that it's not evidencing alteration. I say it plainly is. And there's nothing in the suggestion that somehow, to take an example, an endorsement that simply says the premium is X dollars. On my learned friend's case, that's invalid. It doesn't tell you what changes. Whereas an endorsement that says the premium was previously Y dollars and it's now X dollars would be valid. That is a completely artificial proposition, and there's no support for it in the terms of the GUA. The second suggested defect with the Muir is that it didn't incorporate the GUA stamp. And I understand that to derive from paragraph 4.1 of the GUA, which is on page 198. Where it does say the slip leader shall incorporate the GUA stamp. And leaving aside the artificiality of all that in our context, the stamp, as is evidenced by the examples that are on this page, is a mechanism for identifying who else's approval is required for the change. And if one then goes to the next page, one sees, for example, at 4.3, this picks up a point that my Lord Justice Males was just identifying from the MRC itself. 4.3 says, where the endorsement is not agreed on payment, for example, where electronic messaging has been used, parties shall adopt such alternative arrangements as are appropriate to give effect to the intent of 4.1 and 4.2, as if the GUA stamp is incorporated into the endorsement and the issue. So, there's nothing sacrosanct about the GUA stamp. It is a practical vehicle. It's not the be-all and end-all of amendments, even under the the GUA.
Was the endorsement here agreed on paper?
Yes, the MURA is the endorsement.
So this doesn't apply then, because this is where the endorsement is not agreed on paper.
Yes, the point I'm making at this stage.
The point you're making is there could be other circumstances when it didn't apply, but I don't see how that helps to a circumstance where it does apply.
No, the point I'm trying to make, my lord, is that the GUA is not treating the stamp as an end in itself. It is a means rather than an end.
It's an end to paper agreement on one analysis, but not for non-paper agreements. But you say no, it's just an indicative way of establishing that agreement has been reached.
Yes, I say that it's a vehicle for achieving the purpose of communicating to other underwriters on the same risk the nature of the approval requirement. And I just wanted to show, in relation to this same submission, the last paragraph of this that I want to look at, 201. 10.1.1 is another carve out. Is it where the terms of the slip or endorsement prevail, are provided, shown to and subscribed by each subscribing underwriter for its own proportion. Well, obviously the MURA was shown to and subscribed by Partner Re for its own proportion. So we do say that the stamp objection is not a good one. The last objection, I'm not sure is really pursued. That's the suggestion that the date had to be entered into the GUA stamp. You'll remember that you were shown the endorsement, the 2020 endorsement we were looking at ourselves earlier, by Mr. Killen earlier, and he observed that the date wasn't in the stamp, but he nonetheless admits that that's a valid GUA endorsement. If it matters, there's absolutely nothing in the suggestion that the date needs to be in the stamp in order for it to be valid. The relevant clause in the GUA, I won't take you back to it, but it's 4.2.3. And it says that you must initial a date in the customary place. There's no stipulation that the date needs to be in the stamp. So, the date point really doesn't...
Basically, what is the customary place then? The place that by custom the parties usually do it, or the place by custom it's done under the GUA? It just changes the question, doesn't it?
I'm afraid I can't really help you. One would need market evidence as to what that means, but it's I'm making the negative point that it is not saying you have to initial it in the stamp. Or sorry,
Yes, the evidence, yes.
date it in the stamp. So we do say that if necessary, the requirements of the GUA were complied with, or at least as near as could possibly be complied with. And the idea, in my submission, the idea that what makes the difference between this document, the MURA, having contractual effect and not, is the absence of a stamp, which we've seen from the previous year, the parties didn't even complete. It is really unreal. That then brings me to MWB and ROC, which I'm not going to take you back to. I just want to make a couple of points about that, if I may. First of all, that was a case about no oral variations. And I adopt the point that the observation that my Lord Justice Bales made about the reasons given by Lord Sumption in paragraph 12 of his judgment not being applicable to our scenario. It was also a case in which there was no consideration of this scenario such as we have here, where you have at most a de minimis departure from any contract change requirements. So in our case, the immaterial absence of the GUA stamp. And so, if necessary, I certainly would submit that this is a distinct scenario from NWB and Rock. My friend said, made a submission to the effect that what Lord Briggs's dissent was about was the same sort of point as I'm now arguing. It wasn't. Lord Briggs's dissent was to the effect that he considered that where the parties acknowledge that what they're doing is to depart from the contract change provisions, then they can do so. So if they say, well, I know it says that in our contract, but nonetheless, and that was what he thought should be allowed. Lord Sumption and the majority disagreed with that, but that was his dissent. It had nothing to do with the type of arguments that I'm advancing in this case. And it was certainly nothing to do with the implied rescission, which is, I think, how Mr. Killivan's put it. So, just briefly on implied rescission, which does arise at this stage, we certainly do adopt that as an analysis of what has gone on here. And we certainly say that if one is in that realm, then all of the points that we've just been discussing about the GUA are neither here nor there. There appears to be, as I understand, no dispute as to the principles relevant to implied rescission. You have in the bundle, amongst many other authorities, you have Frangu and Frangos at tab 17. I won't take you to it, but paragraph 98 of Lord Justice Snowden's judgment gives a helpful encapsulation of the principles. Essentially, he says you need to have two documents which relate to the same subject matter and that are so fundamentally inconsistent that the only inference that can be drawn is that the parties no longer intended the earlier contract to be performed. As to those, there is no doubt that the Mura relates to the same subject matter as the MRC. In relation to fundamental inconsistency, I've already had an exchange with your lordships and your ladyship about reading the two clauses together. If I'm wrong about that, then, and the judge considered that I was wrong about it, then these are fundamentally inconsistent documents and provisions, and we are therefore in the territory of implied rescission. My own friend tried to introduce an additional requirement that there needed to be evidence of an intention to replace. That is not supported by authority, and is not right in my submission. It is called implied rescission for a reason. If the parties had actually said we are rescinding agreement A and replacing it with agreement B, then we would be into express rescission. There is an argument in the supplemental skeleton from the appellants that somehow the two clauses, the jurisdiction clause and the arbitration clause, are not fundamentally inconsistent. And the reason that's given is that the parties always intended the exclusive jurisdiction clause to apply. Well, that rather assumes the answer to the question that the court will need to decide. So we say that implied rescission does arise on the assumption that the Mura is a contractually effective document, and if the clauses cannot be read together, and is an appropriate analysis of what has happened when the parties agreed the Mura after previously agreeing the MRC. We've covered quite a lot in relation to the prior year question. The only other additional observations I've made are that it was not a straightforward renewal from one year to the next. My client wrote a different layout, different limits, and a different excess. I've shown you that the Mura itself was different between the 2 years. Most significantly in relation to the service of suit provision was inserted in the second year. I think I'll just have
and the significance of that, you say, is that in the first year there was never any question of suit being served under the Mura because it was, if you're wrong about the endorsement, it was never intended to be the contract. Whereas in the second year, because it was the contract, some provision had to be made about service of suit.
Yes, absolutely. That's a natural reading of the insertion in the second year of service of suit provisions. Certainly in my submission, it's only consistent with the parties thinking that that was a relevant provision that was going to have effect, which it wouldn't do on my learned friend's case. Now, I want to deal, if I can, quickly with the clause 33 point, coming towards the end of ground one, coming towards the end of all of my submissions, but certainly coming towards the end of ground one. And the point was made this morning, for the first time, that a clause in the captive policy defeats the whole argument by making provision as to the effect of certificates. Just to remind you of that, it's in tab 9 of the core report, page 122. I'm going to register a mild protest about this point being taken at such a late stage, simply on the basis that at first instance both parties adduced US law evidence, but nobody adduced any Arkansas law evidence, which might conceivably have been relevant to the meaning and effect of this particular clause. Having said that, in any event, I say the point is without comment. The first point is that I don't accept that the clause here is incorporated into the NRC. You were handed up earlier, I think, the excerpt from Colin Abelman's book on reinsurance, and I won't take you to it, but it's quite plain from paragraphs 3.45 and 3.49 that general words of incorporation do not have the effect of incorporating everything from the underlying captive of the direct insurance. So 3.45, the point is made that those sorts of clauses incorporating in general terms frequently cannot mean what they say. There are clauses which are wholly inappropriate for incorporation in any contract of reinsurance.
Have we got everything we're meant to have from that book? It starts on page 73, which looks as if it's in the middle of a section. I don't know if there's anything on page 72 which is of any relevance or puts in context what is being talked about.
Can I put it this way, my lord? I didn't think that anything on page 72 was relevant, and I hope when I didn't think that, I was being honest about it.
Yeah, okay.
But can we double check that? And if we think there's anything relevant, we can draw it to your attention.
Thank you.
But my understanding is that the passage that's significant is at the top of the page, and then of course you have various paragraphs that explain it as one goes through. And my submission as to broadly what one takes from this is that where one has general words of incorporation of the sort that one sees in the MRC, certainly the coverage provisions will be incorporated. Things like the insurance clause, the exclusions, and so forth, extensions, and the like. But not incidental or as it were, administrative clauses. There are certainly a number of clauses in the captive policy that cannot sensibly have been incorporated into the reinsurance. I won't go through them, but just to give some examples, there are provisions as to subrogation couldn't possibly work at the reinsurance level. Clearly, there's the governing law clause, there's service of suit provisions, and so forth. There's a number of procedural provisions that can't have been intended to be incorporated. And we say that clause 33 is of a piece with those sorts of things and ought not to be incorporated. I adopt to the extent necessary the point that my Lord Justice Miles made this morning about conflict with the contract change provisions. That's obviously without prejudice to my argument that I've been developing that those contract change provisions do not confine. Now, the second point is that whatever this is, this clause is doing, whatever its effect on the reinsurance, the MURA is not a certificate in the sense that's being used here. And I've I'm not going to repeat my submissions about the nature of a certificate and how it's distinct from what the mura is. But the mere fact that the parties in correspondence referred to it as a facultative certificate does not bring it within the remit of this clause, which on its face is plainly concerned with certificates of the other kind, i.e. confirmations of cover and the like. Next, it's important to look at what's in the second part of this clause, where specific provision is made. So starting at the last three words on page 122, it says, except where any additional insureds or loss payees are named pursuant to the special provisions of said certificate of insurance. Well, I can't, I'm afraid, assist with what the special provisions might be. But clearly there's nothing that even vaguely corresponds to that in the mura, and nor would one expect it to be. Secondly, one would not expect in the ordinary courts there to be additional insureds under a policy of reinsurance. This doesn't make any sense. Loss payees, also very unlikely, I suppose possible, conceptually possible, that the reinsurer might agree to pay reinsurance monies to somebody other than the reinsurer, but very unlikely. This clause has just nothing to do with transmission, nothing to do with the reinsurance and certificates in respect of it. So, as a fallback, if this clause is incorporated into the reinsurance, I say it's incorporated as is, as still referring to certificates issued in respect of the captive policy. It's not incorporated and then read as if it refers to the reinsurance. So, for example, in the first line, where it says any certificate issued in connection with this policy, one doesn't, as it were, transform that into a reference to the reinsurance. Because for the reasons I've just given, it doesn't really make sense. So, for all those reasons, we say that this has got really nothing to do with the issues that the court is faced with on this appeal. And like many late ideas, it really isn't a good one. I don't want to deal at any length at all with the question of whether this is an appealable question. Can I just, I think picking up on the exchange that took place between the court and Mr. Killen this morning, just identify what we say about that. Simply this, that one of the issues that the court has to consider is whether the parties intended the mura to have contractual effect. That is a question of fact. If the court thinks the answer to that question is yes, and I'll come back to the appealability in a minute, if the court thinks the answer to that is yes, then I appreciate there may then be other questions of construction which arise.
But are the facts here that they sent this document and somebody stamped it and so on? And the question that we have to ask is whether that document, as a matter of English law, is inconsistent with, or one of the questions we have to ask is whether it's inconsistent. That is a matter of law, isn't it? And although the judge didn't decide in paragraph 50, well, he may not have decided in paragraph 50 of his judgment, which we've hardly looked at, we have to deal with that, haven't we?
Yes, I think your Lordship's question encapsulates the distinction that I'm meaning to draw, which is, question one is, did they intend the mura to have contractual effect? That is the question of fact. But I agree with you. Then the question is, well, how does that fit together with the MRC? Or what does the mura mean? Those are both construction questions. So I'm not saying that no question of construction arises. But the basic point that I'm trying to identify, and I don't think it goes terribly far, is that a question which we're grappling with is, did the parties intend, in signing the mura, sending the mura over and signing it and sending it back, did they intend this to be a contractually effective document? That is a factual question, to which the judge has given the answer yes. Now, that is not to say you can't review it. I think the highest I would put it is that in those scenarios, some deference is shown to the judge's findings, albeit I accept there's no oral evidence that is underlying those findings. And I don't want to put it any higher than that. That's the point I just wanted to identify. My lady, I, like you, am not a fan of breaks, but those who transcribe the things that we
Are
say
fans of breaks.
are fans of those breaks. I have got a certain amount of time left, but maybe a good time to take a break.
How are you doing, though, Mr. Brockbank?
Well, I've actually made very good progress. Well, I've got a long way through my notes, and maybe that's a better way of putting it.
So you're doing well, put it that way.
We will finish in plenty of time.
Okay, well, we'll rise for 5 minutes then. Thank you.
Can you with extra time, James?
Right?
Can you with spare time?
Very warm reception. Always good. I've got more time than I thought it was. I'm not sure whether that's because I just. I don't think I can ask that. No, it'll be 4:15. Yeah. No, I appreciate that. Yeah.
Yeah.
Yes.
I'm going to just check that what time we're sitting to.
Yes.
Because I've certainly done cases before where after about 3 days of me carrying on spouting on until 4:30, the judge has said, "You do realise you're meant to be sitting till 4:15."
So I had wanted that court.
Well, I'll just check.
Do check.
Yeah.
Yeah.
Either way, I'll try and leave you your 10 minutes or whatever it is.
Thank you. I think last time I was in, it was until 4:30, but not because anyone had seen anything. I just think nobody complained when we got to 4:20 or whatever it was.
Right, fair enough.
No, it's a good point.
How long are you giving to? I trust James more than I trust you.
Who is that?
How long are you giving to?
10 minutes.
No, I trust you, James. It's just
He wants me to
Oh no, I was cutting it down by 5
filibuster.
minutes or so.
I'm going to go back to the beginning. I get to the end. Start again. It's always better the second time.
With any luck for me, my case would be better the second time round.
Did you not get anything?
Did you eat? Oh, that was a much better school.
You went for the cafe, you?
Oh my lord.
Did you check with your insurers first?
Not since I volunteered at Rikers Island Prison. Have I had anything remotely approaching what they describe as food? I made it through 2 forkfuls, and then it wouldn't have been. Yvonne Broman would not have approved. Huh?
Cheaper than last time.
That was fine. There were some more things on it, as you say.
Yeah.
Well, it's good.
Good quality.
Yeah.
You went to a French restaurant with Camille.
Camille.
Camille?
I don't know what his.
Maybe it's not good, like
We had a colleague who worked there with his briefcase and it got it knocked to the laptop. So last night I didn't bring it.
Yeah.
Not very, but you can kill the laptop really quickly. Quite nice.
Yeah. Yeah, the roast. Especially that reason the sun should be glass.
Yeah, we've been to brunch.
Did you get, I also sent you the passage.
Yes.
Like
Well,
Yeah, they've done well. There's also my favourite coffee.
I went on maternity leave and I went to get coffee and a walk. They don't do takeaway. So it costs you like, yeah, so you can't, they don't do cardboard cups. But they will let you take buy their takeaway cup on, and you, I think technically you can return it and get a deposit back. I can't remember, but I obviously. So it always goes like a £3 coffee. Over 10. But yeah, cup. It's very nice. Yeah, not
Would be suitable. Some of them are. A lot of it's just the sludge stuff.
today.
Mr. Brockbank.
My name, before I carry on, can I just check what time you're intending to sit until? So I don't, as it were, big drone on and deprive my friend of his reply.
Well, I wondered whether to mention this morning, and then I thought, well, no, I'll keep my powder dry. Generally, it's 4:15. I imagine you think it's 4:30. Well, you'll be disappointed. So here we go.
Very good. Okay, well, in that case, I will endeavour to be swift. I've also managed to trap myself on the seat. There we go. I'm going to venture very, very briefly into the question of reading the clauses together. I've obviously had a warm invitation to deal with that shortly, so I will do so. Can I just say this? The judge gave 3 reasons for not accepting that the clauses could be read together in paragraphs 59 to 60 of his judgment. Since it was remarked that we looked very little at the judgment, we can do so now. In the core bundle, tab 4, pages 68 to 70. Sorry, not pages. Yes, sorry, it is pages
83.
I've given myself a wrong number. 68 to 70.
The judgment is, for me, at tab 7, page 83.
It is, yes. Well, I apologise. I've given myself a
And
false reference.
And you want us to look at paragraph 59 and 60, which is page 93.
Yes.
The assumption that the judgment will be important, I'd actually taken it out and marked it separately, but never mind.
Well,
Hasn't been as important as I expected, Mr. Rotherbank.
I'm very sorry about that.
No.
But I think we all felt that we were encapsulating points that had been traversed in the judgment, but perhaps not without referring to it. Yes, 59 and 60.
Mm-hmm.
And the 3 points that I understand the judge to have made are, first of all, that the clause in the MRC is an exclusive jurisdiction clause, so it's awkward to read it as conferring supervisory jurisdiction. Second, that it's not possible to read them together and give the jurisdiction clause in the MRC a meaningful function. And thirdly, a point about the clauses being in 2 separate documents. And I just want to
there's a 4th point which Mr. Hancock makes, which is that if it's supervisory, well, it wasn't in the first place, so for 8 days it's exclusive, and then suddenly it changes its meaning.
Yes. And the answer to that point is that in this scenario, that's less surprising than it might be in another one, because the parties knew that the Mura was coming. They contemplated from the outset that the Mura was coming. And therefore, albeit one still has that 8-day period, I can't get away from it, it is less of a surprise than it might be in a different scenario. But can I then deal with the other 3? And I'm going to do it very quickly. The first is that although it's an exclusive jurisdiction clause, that is not a bar to reading clauses together. You have in the bundle Sul America at tab 6 of the authorities, which was just such a case, exclusive jurisdiction clause, nonetheless read as referring to supervisory jurisdiction. The same is true of a case called Paul Smith and H&S International, which isn't in the bundle, but is quoted in Ace Capital and CMS, which is in the bundle. It's quoted at paragraph 68 of that case. So it is no bar to reading clauses together, but one of them is an exclusive jurisdiction clause. That has been done in those cases, among others. And the second objection was that it was not possible to give the jurisdiction clause a sensible content, reading it together. Again, we say that is not supported by the authorities. So, for example, in Ace Capital, which I just referred to, which is at tab 4 of the authorities bundle, paragraph 82, the judge found that although the clause might be left with very little purpose, his words, that was not a reason not to give primacy to the arbitration clause and treat the jurisdiction clause as being, as it were, ancillary. And in taking that approach, of course, the courts are willing to overlook infelicities of language. Again, that's the same case at paragraphs 94 to 95. And Sul America is authority for the proposition that you can read clauses together in that way, even where the jurisdiction clause and the arbitration clause point to different countries of jurisdiction.
What is the scenario in which this alternative argument arises. If there is an implied rescission, so that it is the mirror which is or becomes the binding contract, then that's got an arbitration clause. If there isn't, then you don't get as far as reading the clauses together because the MRC continues in effect. So I'm a bit struggling to see in what circumstances there would be two clauses which one was attempting to read together.
Well, I think the scenario, my lord, is that you conclude that the Mura was intended to have contractual effect, but you're not satisfied that it sweeps away the MRC entirely, and therefore one is then in a scenario where parties have agreed two documents, and there's a question, which I accept at that stage is a question of construction, as to whether and how they can be read together.
What about the choice of law then? It can't be New York law and English law, can it?
No.
Surely it's got to be one or the other.
No, in my submission, the way that would work consistently with the line of cases that I'm relying on is that New York law would govern the arbitration and the English law would govern any ancillary relief that was being sought in the English court. And I appreciate that involves a reading down of the law clause, but it's no different from the way in which the courts have read down exclusive jurisdiction clauses to enable them to sit alongside.
So you'd read down the jurisdiction and the choice of law clause then. So it'd be English law only for those things that are ancillary and left to the English courts to enforce.
Yes.
Right.
Yes. And as I say, that in my submission, that is no different from, in nature from the way in which courts have looked at jurisdiction clauses, which on their face are all encompassing, and said, well, no, because of the parallel existence of an arbitration clause, this actually only applies to provide for ancillary jurisdiction.
But why are you trying to do that? I mean, if the logical outside reader, if both of them are so inconsistent, this is New York law, that's English law, this is New York arbitration, that's an English law, the natural thing is to say, well, they're inconsistent, not to try and read them down. Why would you want to try and, on what basis do you think that's what the reasonable, objective reader would have understood?
Well, I'm arguing against myself in a sense because, of course, my primary case is exactly as you put it, that the second document replaces the first.
Well, your primary case is that the second document is the first, and the first continues in existence as modified, with the jurisdiction, the choice of laws has switched.
Yes,
so, but the alternative analysis is that the first document is an ex-parrot, modified, then it's a deceased parrot, and there's a new one now.
Yes, absolutely. So when I say my primary, I was referring specifically to the jurisdiction provisions. So on both my primary and secondary case, my position is that the EJC is no more.
Yeah. EJC is.
I won't try and quote or misquote Monty Python.
Am I right in thinking that the cases to which you refer are all cases where there are two clauses, sometimes by incorporation, but in a single contract? So the court's got to try and make sense, or to see if it could make sense of both of them, whereas we have a different position here where they are in different documents doing different things, and that particular problem of needing to find a reconciliation if you can doesn't arise.
As for the first part of your question, yes, I think you are right. There is a case, sadly and miraculously not in the bundle, in which Mrs. Justice Gloucester decided a case called AXA and ACE Global Markets, in which there were two documents, but it isn't our case in that one of the documents was incorporated into the other. And so it is a two-document case, but it isn't. I'm not suggesting it's the same as our facts, in that you won't have one agreement followed by another.
But it's clearly a single contract case.
Yes. So probably the closest one gets is the case which is in the bundle, which is the Surrey and Suez case, which is at tab 13 of the bundle, where there was a primary contract, and there were subsequent variation contracts, and the resolution in that case was effectively that the judge treated the clauses in the later contracts as really specific to the issues that arose under those later contracts. So it's not quite the same kind of reading together as one gets here. The relevance of the case is that he, in so doing, he had to read down the scope of the clauses in a similar way to the way in which the courts had done it in the other case. So again, I'm not going to go so far as to say it is on all fours with our case. It plainly isn't. But it is a case in which there were documents agreed at different stages that the judge then grappled with the idea of reading them together. And to this extent, it gives succour to my argument in that he did do that by reading down one of the clauses so as to give full effect to another. And I should say, just so I'm not in danger of misleading the court, that he considered the question of whether they could be read together in exactly the same way as, for example, in Sulla Merita, and he rejected it on those facts. That's paragraph 93 of his judgment. But the reason he rejected it is because the first contract that I talked about already had in it two jurisdiction provisions. So if you like, that point already arose in the first contract. He said, well, I can't do it again with the later contract. So anyway, that's as far as I can take that point. And I hope you won't mind if I move on from that part of my argument. I'm going to move to ground 2, which I'll take very, very quickly. First thing to say is that my known friend Mr. Killen said something to the effect that the judge's decision on ground 2 was in a way infected by the decision he reached in relation to the first one. We don't accept that. It's quite plain from his judgment that he is approaching the anti-suit injunction or the anti-arbitration injunction point from the perspective of the jurisdiction clause being valid. So he's putting aside the findings he's made previously and saying, well, in this alternative universe, what's the answer? Secondly, in my submission, it's clear that the judge's decision in relation to whether he would have granted injunctive relief was an exercise of discretion. And I'm not going to take you to authority in the time we have, but there's a case in the bundle called Echo Bank, which I expect the court is familiar with, and I refer you in particular to 137 to 138. 140 and the last two sentences of 141 for what I say is the obvious proposition that these sorts of points are questions of discretion.
But given that he decided that it was New York, that this didn't arise, do we have to be satisfied that his expressions of view, because they are nothing more than an expression of view, is an exercise of discretion, he has to be wrong or wrong principle or outside the range, or do we start afresh if he's got it wrong on the New York thing?
Well, in my submission, he has decided this part of the case, albeit on a contingent basis, and therefore one is in the ordinary situation. And what one's looking for is to see whether he has made an error of law or is so clearly wrong that no reasonable judge could have come to that decision. Now, in terms of the errors of law, I'm going to have to take this at a gallop. But the first is said to be, well, there's a point made about a touchstone said to be derived from the Qingdao case in paragraph.
Well, just before we look at whether there was delay of 2 months or 6 months or whatever it was,
yes,
and whether that was culpable, what do you say about the point which I asked Mr. Killen about? So what will happen if the appeal succeeds on ground 1? In that case, the stay will be lifted, so
yes,
the action in England will proceed.
yes.
If the arbitration is not injuncted, that will also proceed. Apparently there's a hearing in October, so it may be that will reach an award before the English proceedings would get to judgment, but there would be questions about whether an award was enforceable in the light of the decision of the English court that the arbitration clause was not agreed between the parties. It would be chaotic, wouldn't it? So what should happen?
Well, I think...
And did the judge take that into account?
Yes. Well, in my submission, the scenario that you have painted is the scenario that confronts the court in almost every situation rather, in which it's considering whether injunctive relief of this kind ought to be granted.
No, it doesn't, because usually the question is somebody claiming abroad,
Yes.
and if they're injuncted, then it's abroad or nowhere.
So in a scenario where the English court is asked to injunct foreign proceedings, the foreign proceedings are on foot. It's typically the case that there will also be proceedings in this jurisdiction in support of which the injunction is being sought.
It may or may not be. Anyway, you go on.
So the typical scenario is that if the injunction is not granted, there will be proceedings in two jurisdictions. That is an absolutely standard feature of injunction applications of this nature. The English court is being asked, not in every case, but in a great number of cases, to uphold its own jurisdiction over the issues in question. And if it gets to this stage of the analysis that we're talking about now, it's decided that it does have jurisdiction, and indeed that potentially it has exclusive jurisdiction, but it's considering whether or not an injunction should be granted. In any case, in that scenario where it doesn't grant an injunction, the hypothesis must be that the foreign proceedings will continue. The English court also has jurisdiction, as it has ex hypothesi found. Proceedings presumably either are on foot or will be on foot in the English jurisdiction. So I'm not submitting that it's not a situation which might create issues, but it is a common situation. And therefore, the fact that that might be the case, but nonetheless, the authorities demonstrate that, for example, delay can bar relief, illustrates that it's not an answer to this part of the case to say, well, it would be very convenient to have proceedings in two jurisdictions. In a sense, the court is, in a scenario where the court doesn't grant an injunction because of delay, it's saying, well, you brought this on yourself.
Where does the judge consider this?
Well, I don't think I can submit that he expressly considers it, but in my submission, he must have had it in his mind, because he received a great deal of evidence about the situation in the arbitration, which he knew was going on. It's not a great leap of logic from there to understand that if one doesn't injunct arbitration, it's going to continue. And so I submit that it's not really a criticism of his judgment that he doesn't set out in terms what must have been, what was in effect the starting point for that whole part of the case. The whole thrust of the application for the injunction was, we want to proceed here, we've brought a claim here, we don't want the claim in New York to continue. And so he must have had enough. In my submission, it was unnecessary to spell out that if he didn't grant the injunction, one would be faced with the potential for two sets of proceedings. My lady, I don't want to leave Mr. Killen with no time to say anything. Well, I shouldn't leave Mr. Killen with no time to say anything. So can I really try and rattle through this? It's suggested as one of the errors of law that Mr. Justice Bryan in the Qingdao case at tab 10 of the authorities had come up with a touchstone. All I want to say about that is that in identifying this touchstone, he referred, in paragraph 29.2 of his judgment, he referred to Ecobank and to the Kishore, both of which are clear authority for the proposition that delay on its own can be sufficient to bar relief. And to that extent, not really supportive of the supposed touchstone. In any event, there's no ground for saying that Mr. Justice Bryan was, as it were, setting down a rule that had to be followed. And indeed, the way he expresses it in 29.2 itself is by reference to what might typically be the case. I can't remember the exact adverb that he uses, but something of that nature. We do make the forensic point that this touchstone was not even identified to the judge by Mr. Killen at any point in writing or in orally. at first instance. So it would be something of a surprise if it was so central to his consideration of the point. Next, comity and anti-arbitration relief. I think all I have time to say about that is the judge clearly recognised it was necessary to have regard to the nature of the relief that he was granting and the fact that comity might have different implications in that context. It's worth saying that even in the anti-suit context, comity is rarely a dominant factor. Because, as the courts have said from time to time, well, there's no injunction on the court, and indeed all you're doing is upholding a contractual right. And so there are frequent references, such as EcoBank itself at 106, to the effect that really comity is of relatively limited significance, even in the anti-suit context. So the idea that the judge's decision in this case was vitiated by failing to appreciate the difference between the slight relevance of comity in the anti-suit injunction cases and the slight, or perhaps slighter relevance in the anti-arbitration cases. It's really a very subtle distinction, not one that, in my submission, amounts to an error of law, particularly given that he himself identified and talked about that distinction. I haven't got time to develop why, in any event, I would say that comity does apply in the arbitration context. I adopt the point that my Lord Justice Wells made about the supervisory court's jurisdiction, but there are other points that could be made, including to the effect that many arbitrators these days operate in arbitral bodies such as the ICC, which are very akin to the way in which courts are managed and operated, and that arbitrators are very much people whose time is valuable to potential litigants, such that there are still considerations in the arbitration context about wasting the time of arbitral tribunals, albeit obviously not as important as the judiciary. Delay in fact, which I will have to deal with in 1 or 2 minutes. A simple point is that the appellants waited 6 months to bring the application, despite knowing from the outset that they had a basis to make such an application. The central flaw in the way that they approached the case on the delay is to start the clock too late. So it happened this morning, or this afternoon perhaps, with Mr. Killen, by inviting you to start thinking about the position in September. And then he said, oh, well, we've made our application in November, and that's only 6 weeks later. Of course, that sleight of hand has cut out the bulk of the period in which they weren't doing anything, but they could have done. And submissions are made to the effect, well, it would have been very surprising if we'd come to the court to seek an injunction before we knew what was going to happen in the arbitration. In my submission, the contrary is true. The very reason why litigants are required to come to court promptly is to avoid seeing what happens in the non-contractual forum. And indeed, there is plenty of authority for the idea, or for the proposition, that cannot wait and see and then say, well, that's a justification for my delay. Can I just give you one reference? You have in tab 19 of the authorities bundle an excerpt from G on commercial injunctions. And paragraph 14086 is one place where that point is made. It's also made in EcoBank, in the Kishore, and other cases. Can I just conclude by looking at the standing back paragraph in my own friend Skeleton? It's in core bundle tab 2, page 40. And he says, standing back, it's paragraph 91 at the bottom of page 40. Standing back, it is apparent that he's saying that none of the reasons why delay might bar anti-arbitration relief applies. He says there's no prejudice to partner re. Well, we're going to accept that partner re has engaged in and incurred significant costs in arbitration. Second, there's been no reliance on the elapsed period. Well, there has, to the extent that we have, as I just said, wasted resources if an injunction is now granted, pursuing an arbitration, which until November the appellants did not suggest that they were going to seek to injunct. And thirdly, I think that deals with the third of his arguments as well. Fourthly, as to comity, we don't accept that. But in any event, the judge's decision was not principally based on comity, and comity is not a prerequisite for where there is delay, and delay is unjustified. That is enough. I have rattled through that, I apologise, but subject to any questions, those are my submissions.
Thank you very much indeed. Mr. Killen?
Thank you, my lady. My lords, I'll be as brief as I can be. I'll propose to take the points in a bullet point format, but please do say if it's not clear what it is I'm talking about. The first point is, my learned friend, when comparing the two documents, make a submission that clauses such as Clause 4 were lost, and Clause 4 was the Books and Records clause in the facultative certificate. I simply make the point that that is the only clause which could be held to be any sort of operative or substantial clause, which would be lost, to use my learned friend's term, if the MRC applied to the exclusion of the facultative certificate. The second point is that my learned friend suggested that the facultative certificate was not in a standard form, but that is, we say, what the agreed evidence was between the parties. Supplementary bundle tab 22, page 228, is a witness statement from Mr. Hennessy, partner Re's underwriter, making the very point that they are standard, that the Mura is standard form. And then likewise in the transcript, supplemental bundle, tab 28, page 293, below, my learned friend confirmed that yes, it is common ground that they are standard. Those are the clauses in the Mura, and I think familiar to both parties. So certainly, so far as my learned friend's submission was that those clauses were not standard form, certainly they look standard form, we say that that is a departure from the evidence. Dealing with what my learned friend referred to as the swept away argument, my learned friend's, the end point of my learned friend's submissions was to say that really, because there was so much in the captive policy, the difference of what was lost if one lost the MRC was really inconsequential. But I went through the process before of identifying those clauses that we said were substantive to the operation of the reinsurance and do not find any place in the captive policy, do not find anything in the facultative certificate. And they were the bespoke agreed communicable disease wording, which my learned friend acknowledges, the reinsuring clause, which he sought to play down as the difference between what was in the facultative certificate and the MRC, the limits provision, the requirement to maintain primary underlying insurance, the uncollectability of other insurance, the claims control clause, and the several liability clause. These are, we say, all operative provisions of reinsurance, and they would all be lost if the MRC ceased to apply. Next, on the English law and jurisdiction clause in the MRC, just to clarify the position, because I think my learned friend's submission, although I think it might have just been an elision in what he was saying, was that it was already there in the MRC. Now, he did at one point say already there from other parts of the programme. I just wanted to make clear that the way that the MRC is put together, and this is what Mr. Justice Jacobs was addressing in the John D. Wood case, is that the subheadings, or the side headings, sorry, are present, but what is in fact entered in is blank. So there isn't a form of MRC that includes that jurisdiction and choice of law wording that is entered in. Now, there's no evidence that it was negotiated, and that's what my learned friend says, and I agree that. I can't point to anything that shows that. But it wasn't presented as a whole document, as an MRC, with that in. And that point goes also to the GUA, to the General Underwriters Agreement. That is not pre-printed into the MRC. Somebody made a choice to put that in. So that's the basis for submission that we say that the MRC is bespoke. And it goes particularly to the GUA and to the jurisdiction and choice of law clause. On commerciality, my learned friend characterised my submission as being bound up with the swept away argument as to whether it was commercially sensible for there to be the MRC replaced by the facultative certificate. My point is rather broader, which is the point about the change in governing law. And I made that before, but I didn't want it to be thought that my commercial considerations point was simply to do with the clauses that were lost. That's part of it. But a larger part of it is that absurdity of having one reinsurance governed by English law swapped out by another reinsurance governed by a different law, and all that entails. And particularly when one remembers that this was 8 days, in the prior year it was 29 days. The facultative certificates are said to come through at some stage. We say that says there's no urgency. Why would one agree a completely different contract of reinsurance to kick in at an uncertain date? That's the absurdity we rely on. Related to that as well, my learned friend said that the point of using the MRC was as a vehicle to bind various bits of the market. Now, if I may say, I think that was possibly a little bit of ad-libbing on my learned friend's part, but it's difficult to see why that is a sensible way to use an MRC. It's partner Re's case that the Mura was standard form and known to the parties. So if that's the case, then why would they not just send the facultative certificate in the first place? It didn't need to be negotiated. Everyone knew what it contained. If what they meant to agree was a contract subject to New York law, then they should have just bound the market by sending the facultative certificate. So I'm not sure that my learned friend's justification for why the MRC is used, in fact, stands up. Turning then briefly to the prior year and the endorsement, my learned friend made a submission that there was some ambiguity as to what the endorsement referred to. The endorsement is at page 50, supplementary bundle, tab 3. And my learned friend said that it relates to the contract with the unique market reference at the top of the endorsement, and said that that unique market reference appears on the facultative certificate. But it does not. The unique market reference is B0713, and then followed by the policy number, PRPNA 2003490. The facultative certificate only contains the last part of that, the policy number. The only document from that year that contains the unique market reference, the B0713 part, is the MRC, and one can see that in the market reform contract on page 6 of the supplementary bundle, unique market reference number, and it's there stated. There's also the point that we say that then answers the question as to what that endorsement is referring to. We say it's clear, and we endorse the comment from my Lord Justice Lewis, that if something is subject to something else, well then that means it is subordinate to it. But the important point is it can't be subject to itself. And so if the first document is the facultative certificate, then the second document must be the MRC. And we say that that is plain. Now, there is an email at paragraph 51, it's referred to in my skeleton, where that endorsement is explained, and it's said, and this is at page 51, that the purpose of the endorsement is just to provide you protection, that the FACCERT is overall subject to the terms of the MRC. I accept that that is a subjective assessment of what a contractual term means. We are in a slightly unusual situation where that would be allowed in if there were a claim for rectification, but we can't possibly be expected to claim to rectify the prior year's policy in order to make a point about the next year. So I show that to my lady and my lords, but I don't suggest that it is necessarily determinative. The next point is the contract change argument. I've addressed already the fact that we say it's not boilerplate language, it is added into the MRCs. The MRC implementation guide, which I won't go to, but it's in the supplemental bundle at tab 5, pages 69 to 70, makes clear that the parties are to choose what they put in as the contract change provisions. Now, I accept that the GUA is primarily used between reinsurers, and this argument was made before the judge. The judge, however, accepted, and we say rightly, that just because that's its primary use doesn't mean that parties could not choose to use those formality requirements in order to agree bilateral amendments, and we say that's precisely what happened here. The contract change provisions in the MRC are clear. All changes are to be agreed in accordance with the GUA. Now, what my learned friend says is essentially that the GUA applies, but only as between reinsurers on the same layer. But of course, in this MRC, the only parties to the contract are partner Re and my client, Tickle. So it can't possibly be the case that they chose the GUA thinking it would apply to agreements between reinsurers when there's only one reinsurer on this agreement. And the MRC doesn't say that this applies as between reinsurers. The MRC says this applies to all changes. My learned friend's suggestion is, in essence, to read any change or all changes as being any change between underwriters but not otherwise. And the reference to the accord messaging system and any change in any legally effective manner, we say doesn't take matters much further. It doesn't say that you can do this in any way contrary to the GUA. It says it has to be legally effective. We say the question of whether it's legally effective is determined by whether it complies with the GUA. And so the change has to be legally effective. If the parties have acknowledged it has to be in line with the GUA, well then the GUA needs to be followed. But what the accord part of the writing refers to is simply the communication of the changes that have been agreed. So it doesn't impact upon what is legally effective. It simply says how that can be communicated. Now that's not relevant to this part, but we say that doesn't change what is a clear statement that the parties are to follow the GUA into a broader statement that they can be rather wider. Very, very briefly, reading the clauses together, I'd just like to point out that Surrey and Suez, my point that I made in my submissions was that there are two features which we say this would be the first case to find that clauses could be read together that has not been in any of the other authorities, and they are first that the clauses are in two different documents, and second that the governing law, the jurisdiction is different from the seat of the arbitration. And Surrey and Suez was two documents, albeit that I think they were incorporated into one another, or at least cross-referred to one another. But they were both English jurisdiction and English-seated arbitration. So we say that there isn't any authority that says that two clauses can be read together across two documents and across two jurisdictions. On the incorporation on clause 33, my learned friend made two submissions, contrary to it being incorporated from the captive policy. One was about Arkansas law and what the applicable law was. Now, it's in the extract from Edelman, but it is, in any event, I think, relatively uncontroversial, that the governing law provisions and jurisdiction provisions generally are not carried through because they are said to be personal to the parties. So when the clauses are carried through, they're not carried through subject to the Arkansas law clause. And so we say that generally it would, if it was carried through, then it would be carried through and considered in accordance with English law. As to the examples of other clauses in the captive policy that my learned friend said would not be carried through, we say this is a minor point, really, because really the question for the court is whether clause 33 would be carried through. But in any event, the subrogation clauses would not often be carried through because they'd fall foul of the manipulation rule. And likewise, the choice of law arbitration, exclusive jurisdiction clauses and the like would be considered personal. The question for this court is not, is the captive policy en masse dragged in, but is clause 33 dragged in? And as I said as I submitted in my submissions, we say that all of the four requirements or guidelines from Mr. Edelman extracted from HIH are satisfied. Very briefly then on implied rescission, last point of reply on ground one. Just to clarify something, if I had given the impression that I said that there was an additional requirement that there be evidence, then I did not mean to. My point was that if there is an implied rescission, there has to be some basis on which the rescission is implied. And that is either because of the nature of the agreements or by writing or by actions or some other method. So when I refer to evidence, I think it was shorthand for that, and I apologise. What we do say, though, is that franjus is rather a thin basis for my learned friend now to say, and I think today was the very first time he'd said that he doesn't pursue, or doesn't pursue with any vigour, as I understood it, his primary case that he has always run, that the MRC and the facultative certificate as we run together, but rather is content just to rest with the facultative certificate. But we say that that is difficult in two senses. One, franjus is a case where the finding on implied rescission, such as it was, appears to have been obiter. It's paragraph 98, tab 17, which is volume 2 of the authorities bundle. And there are a number of factors which we say distinguish it. First, in franjus, there was an agreed variation to the contract, and the question was whether, by that variation, the parties must have intended to bring the original contract to an end. But second, in any event, paragraph 98 is put on a conditional basis. Lord Justice Snowden says, "I do not think it's necessary to resolve that issue, the issue of implied rescission. Whatever the precise requirements of the law in that respect, I consider that it is clear that rescission will only be implied if the subsequent agreement / common intention of the parties, 1, relates to the same subject matter as the earlier contract, and 2, is so fundamentally inconsistent with the earlier contract that the only inference that can be drawn is the parties no longer intended the earlier contract to be performed." So it's setting out a bare minimum on a conditional and obiter basis. And we say that if I'm right on the reading together, then implied rescission simply does not arise. Certainly we say it would be a bold thing to find, particularly we say in light of the GUA, which we say does bring this more squarely within MWB and ROC, because we say that it's difficult to get round, and that is in essence the mischief that Lord Sumption was addressing, by saying, well, it's implied rescission, rather than just by saying, well, it's a separate contract. They essentially amount to the same thing. And we do say that it would fall foul of the approach in MWB and ROC. My lady, my lords, I see the time. I'm not sure I need to say anything more about ground 2 or about ground 1, unless there are any further questions.
Please do so if you think it's appropriate.
My only point on ground 2 was simply to say that, I said my only point, my 2 points on ground 2 that I wanted to make are, first, we say that the point that my Lord Justice Mayles made as to the fact that the 2 proceedings running at the same time is an important factor. We say the fact that it wasn't considered by the judge suggests that the wrong test was applied. The second point is that my learned friend criticises the waiting until the tribunal was constituted and says that there is plenty of authority that suggests that this should not be something that is done by a party seeking an injunction. We've got the Court of Appeal judgment in Enker and Chubb in the authorities bundle. In the Court of Appeal in Enker and Chubb, and delay was only addressed in detail in the Court of Appeal. It was not then disturbed by the Supreme Court. In that case, there were proceedings going on in Moscow, and the party applied and took a jurisdiction challenge in Moscow, and it was held in that case, I think by Lord Justice Popplewell, that it couldn't or shouldn't be criticised to try and enforce your rights with that other tribunal. Now, we say that is the case here, but we say this case is even stronger. First, because that is precisely what we were doing. We were going to the arbitral tribunal and saying, will you stay your proceedings until the English court has decided? The subtext of that being, and if the English court decides against the arbitration, that you go away peacefully. But the second point is that my client was not actively challenging the jurisdiction, and that is what the mischief is that's referred to in Ecobank and Tanno. But what Ecobank and Tanno makes clear is that in that case, it was the fact that jurisdiction and merits had to be considered together. In this case, my client didn't even go as far as saying to the arbitral tribunal, we want you to decide your jurisdiction and decide it against yourself. We simply said, wait until the English court deals with this.
Can you just give us the references to the paragraphs in Anchor? Don't take us to it because it's a long judgment.
Of course, paragraph 111.
Okay, thank you.
My Lord, I'm sorry, I didn't address Anchor because my learned friend didn't address it in his own submissions, but the important point in Anchor is that the challenge to the foreign jurisdiction was made after an application had been made to this court for an injunction, and you get the chronology in paragraphs 15 to 28 of the judgment. So I'm sorry to rise, but it's important to make clear that that case is not authority for proposition my learned friend just made.
I'm sorry, my lord, paragraph 113. I had not thought that was the chronology that I will obviously review. My lady, my lords, unless there is anything else, please conclude my reply submissions.
Two questions from me, if I may.
Of course.
One is, has there been either an application for permission made or granted in the Tyson GIC case?
An application was made to the judge at first instance. The judge did not grant permission to appeal, and no application was made to the Court of Appeal. But I'll just no application was made to the Court of Appeal.
Time has now lapsed.
Yes, my lord.
Okay. The other one, which you might think is a bit late to be asking a question like this, but why does any of this matter? I mean, you would think, would you not, that our commercial arbitrators in New York, experienced in insurance and reinsurance, would be perfectly capable of deciding a dispute about misrepresentation, as I understand it, of underlying values, and that the commercial court here would likewise be perfectly capable. You might not want to answer that question, you might not be able to, but the parties seem to be spending an awful lot of money on this point, and it's sometimes helpful to know, if we're allowed to, what a case is really all about.
My lord, I think I will limit my answer to that question only to saying that there are, of course, differences between certain duties that would apply if the Insurance Act applied and duties that might apply in New York. I suppose all I will say is a view has clearly been taken on both sides as to which might work better for them.
Fair enough.
Thank you very much indeed. I think that's the end of our questions for you. Thank you very much indeed to both of you, to those behind you and those behind them, in preparing this case so fulsomely and well, and for your very clear submissions. We're very, very grateful. We will reserve our judgments. I don't think you'll be surprised by that. You will also be very aware of the procedure in this court. First of all, when our draft judgments are circulated, please take the embargo extremely seriously. You will have already, I think, have provided to our clerks the list of email addresses for circulation. If it occurs to you that actually someone else should be on that list, please apply to extend it rather than just sending it for everyone's sakes, and particularly yours. Secondly, you'll be even more aware that the way in which these matters are dealt with is that we are grateful, very grateful, for your typographical corrections. We are not grateful at all for any attempt to re-argue any of the points. I'm sure you won't be tempted to try to do so. And then, in addition, we always hope that you will be able to agree an order, and that if you can't, that you will put in short, by which I mean short, submissions about why your version is the right version, and that will be dealt with by us on paper. And as you will also know, these days judgments are handed down electronically and no one is required to attend. We're extremely grateful to everyone. Thank you.
Thank you very much.